Hello, everybody. Thank you for being here, and thank you for those who will watch this recording later. My name is Michelle Thorne. I'm the co-founder and executive director of Care for the Caregivers. Today, we are so excited to have Emily Taylor here to talk about supportive decision making. So, supportive decision making passed last year in Arizona, and I know that many of us are like, yay, we were very excited. We were all celebrating. And then it's like, but practically, what does this mean? And so I'm so excited to have Emily on today because it is a big question, right? Practically, what does this mean for our community here in Arizona in terms of guardianship options for our children? So, Emily, thank you so much for being here and for presenting on this topic because it is very information, centric, and it's something that a lot of people are just kind of like, oh, what does that do? So thank you for going to answer this very important question of what the heck is supportive decision making. So thank you.
You're so welcome, and thank you for having me. No pressure. I will try to explain what exactly this means and what it might look like. I appreciate you having me, and I'm excited to talk about it. Just to quickly mention, I'm an attorney, and so disclaimer: this is not legal advice. You're not my client. All those fun things. But with that said, happy to speak with anybody privately, of course. A little bit about me and my practice. I grew up in the Midwest, have been in Arizona for going on my 24th year, attended both ASU and U of A. And since that time have practiced law for the last 16 years in the area of estate and special needs and long-term care planning. So feel very, very lucky to be a member of a couple great national organizations such as Special Needs Alliance, Academy of Special Needs Planners, as well as NALA. And I'm excited because in those organizations, when we get together a couple times a year, I get to hear what other states are also doing. So where supported decision making is brand new and hot off the presses here in Arizona, I've had a bit of exposure to how it's kind of operating in other states and what that looks like as well. So with that, it seems kind of silly, and I imagine you probably don't need me to remind you, but I just want to talk a minute about what are decisions and what decisions do we all make, and kind of some of the human condition of making decisions, from the small things that happen in our everyday life about what time we wake up in the morning, what clothes we wear to school, to work, what we watch and consume on social media, on television, all the things that impact us, as well as some of the bigger things, like what kind of job am I going to have? What kind of career do I want? Who am I going to marry? Who am I going to have relationships with? And of course, you can see the image there of spaghetti. So what are we going to eat for dinner every night for the rest of our lives? So with those things, we have a lot of good decisions we can make, and we also have a lot of harder decisions to make. So if I need to quit a job, or if I need to have a conflict with a friend, maybe sometimes we're making bad decisions, still making decisions. And so, this time of year, I'm always weighing the consequences between choosing the vegetables versus the plates of cookies. So drinking alcohol, consuming other substances, all types of decisions that we make. And so for each of us in our own lives and in our children or individuals in our lives, we're all looking to others when we make decisions. And so I know, we've got a number of different supporters. We've got some of our ancestors, our grandparents, our parents, we've got friends, we've got teachers, we've got our new boyfriend or girlfriend, we've got the bad guy, the good guy, all sorts of people we can turn to when we're looking to make a decision. And so that concept of supported decision making starts to look a little bit interesting. I shared here some of my fun decision maker supporters. You can see on here, we've got my family, we've got my dog. Seems kind of strange. How does my dog support me in making decisions? But I tell you, she supports largely what time I wake up in the morning and whether or not I go for 2 walks a day. I've got some of my team members, and if we kind of just think about who is in your life, supporters can be of all varying types. And the funny thing is that when I'm making decisions, there's a bunch of different types of support I might want. What kind of emotional support do I want? Do I want somebody to just listen? Do I want somebody to take on tasks for me? Do I want somebody else to actually make the decision, or do I just want to vent? And so a lot of times to kind of think through these different pieces of decision making and how we are supported in that in our own lives, it starts to kind of frame a conversation about when we're thinking about decision making for other people. And so with that, we can see a lot of opportunity where things can go wrong. If at the end of the day, I have supporters and they are helping me in those different ways that I've asked them to, at the end of the day, with decision making, unless something's different, I am still making my own decisions. And of course, I included my dog at the end there because, as I alluded to, she makes decisions for me sometimes too. So now, if we kind of step back and put ourselves in the shoes of the people we're caring for, whether that's a child or in some cases a parent or a sibling, there's all levels of caregiving. We have to think about how, as a caregiver or as a potential legal decision maker, we're supporting somebody in making decisions, or sometimes we're actually substituting our decision making. And so that's where we start to see this really blurry line legally, and trying to come up with tools and solutions for when individuals have perhaps limited capacity to make their own decisions, perhaps vulnerability, and they're much more vulnerable to outside influence. Just kind of going through that exercise of thinking about how you make decisions, who supports you in making those decisions, and how you might view yourself in different roles can really help to frame what is supported decision making. So with that, legally now, as Michelle alluded to, we have a new law as of this fall that is in our statute that says we have something called supported decision making. And the statute itself, not terribly long, but it in essence is a legal concept that allows individuals with disabilities to still make choices about their own lives with support from a team of people they choose. It allows that network of people that are trusted to be a part of a support network to help with or assist with decision making. So we've got to break that down. So, and I'm going to use the acronym SDM just because supported decision making is kind of a wordy concept. But what is it in the law? And so within the law, you'll see a couple different things. It can be a written and witnessed agreement. So there is provided in our statutes actually an outline for a form. Happy to provide that to you, Michelle, as well, so we can share that with the video. It may be an informal agreement, right? So as I shared, I have a network of supporters who help me make decisions. That's very informal. I get to text the friend I know who's going to give me the answer I want. I get to ask the employee who might give me the feedback I want. There's a lot of informal arrangements, and that's also held in our law. Supported decision making is a part of person-centered planning. So of course, when an individual has a disability, allowing them to lead and in some cases control some of that centered planning. And it is legally a less restrictive alternative to guardianship. So what we're going to do today is kind of walk through the different pieces of supported decision making, and then what we'll do in the long run is compare that to where that falls on the spectrum of decision making capacity between individual autonomy, powers of attorney, supported decision making both formally and informally, as well as guardianship and limited guardianship. And so the question that Michelle was alluding to again is, what exactly is supported decision making? And what it is, in essence, is this concept that really came to light as part of a 2006 Human Rights Convention on the Rights of Persons with Disabilities. You may or may not know that it was not actually ratified by the United States, but it stated that parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, and that parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. And so with that, nationally, there's been several conferences that focused on person-centered planning and became a part of starting this concept of supported decision-making nationally. In 2017, a number of states, including now Arizona, adopted what's called the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. in response to some of these issues that were coming up on these national level conversations. And so with that, under the Act, before appointing a guardian, a court must specifically determine whether supported decision-making is an appropriate, less restrictive alternative. The Act does not currently otherwise regulate supported decision-making. And so, for example, historically and continuing, when we go to court to file for a guardianship, which is different than supported decision-making, it's actually taking away somebody's rights to make decisions and granting that to somebody else. We do have to avow and affirm with the court that we've considered all other less restrictive alternatives. So something to keep in mind as we kind of go through this process. And so with that timeline, supported decision-making as a legal concept back in the 80s and 90s was introduced internationally. Sweden and Canada really were some of the front leaders on implementing that. In 2006, we had the convention, as we discussed. And then in 2015, Texas is the first state to introduce and enact a supported decision-making statute. Historically, as many of you know, this concept has been introduced in Arizona, and over the years, some years it took a little bit longer of a run than others, but it was not successful. This past summer, we had a series of guardianship type bills introduced, and one of them was supported decision-making, which did not on its own move forward. However, as a response to a guardianship bill, supported decision-making was later added back into that, and it passed and was signed into law on June 20th by Governor Hobbs. So with that, we had to wait for the session to close and then the laws to go into effect. And so brand new, about a month and a half old right now, we have supported decision-making in our statutes. So with that, under the law, under the statute that allows for this concept to be formalized, it allows for supporters to do certain things. One of those things is to assist an adult in understanding the options, responsibilities, and consequences of those decisions. And so again, if we're kind of thinking back to some of the silly examples, if we meet a new romantic partner and we're, having dinner with our girlfriends and we're talking about whether or not we continue dating them or perhaps accept an offer to be engaged or to get married, the supported decision-making is very similar to that in the sense that supporters can, under the law, under this agreement, more formally or less formally, support that individual in considering all of the different consequences, options, and what that might mean. And so with that, a supporter can also assist the adult in accessing, collecting, and obtaining information that might be relevant. So going to maybe schedule an appointment with a family law attorney to consider a prenup, that type of thing more formally. The supporter could also, go through medical, psychological, financial, educational, and treatment records. So getting access to records and helping provide that information. The supporter can assist in understanding and assist in communicating. However, with all of that said, what the supporter cannot do, the supporter cannot sign legal documents on behalf of the adult or bind the adult in a legal agreement. They cannot, of course, intimidate or deceive the adult to gain the agreement or provide any of the authority provided in the decision-making agreement. They cannot be compensated, and they cannot continue in their role as a supporter once that agreement's been terminated or the adult is determined later incapacitated or a guardian is appointed. So what are the consequences? Under the new law, the consequence of a supporter violating one of the things that they're not allowed to do is criminal prosecution and civil penalties. And so that is one of the good things, is that if this agreement's in place and one of the supporters violates that agreement, then of course there's some consequences to that. How that actually plays out is to be determined. So if we go back to our original conversation then, what is not supported decision-making? That means under the supported decision-making, we're not substituting judgment. So if our adult with a disability who has retained their capacity to make decisions makes a poor decision, as we are all mostly allowed to do, we cannot substitute our judgment on their behalf. We also cannot make a best interest judgment or decision, and it's not somebody else making your decisions. So it seems kind of funny that we have to break down each of those terms in terms of what is supported and what is decision making, but it really starts to come into focus about how this may or may not work in perhaps your situation. And so at the end of the day, the true answer is that supported decision making and supported decision making agreements are a new tool that we have available to us in our legal toolbox that will work for some individuals, but not for all. And so that's great. And that's why it's so exciting to see this movement, is because we want to make sure that we've got this tool available for the right situations. And so in some cases, though, as a parent or a caregiver, doesn't really answer our question about what works best in your situation. And so for each case, you're going to have to undergo this analysis of where do we fall and how is this tool the appropriate tool for us to use. So as we walk through that, that's going to be a bigger part of what we're thinking about. So as you can see here, we've kind of got a spectrum of different legal options when it comes to decision making. And this is true, frankly, for each of us as an adult. On one hand, the day we turn 18, we may have complete autonomy to make decisions. And we, at that point, can legally bind ourselves to agreements and contracts and make good decisions and make bad decisions. Many adults, or most adults, if we aren't moving further down, should have a power of attorney in place. We're going to talk a little bit about powers of attorney and how they can be a part of supported decision making, but are also a part of having complete autonomy. We have that informal supported decision making agreement and arrangement. And to be honest, there are a number of families prior to the law passing who were acting under this concept of supported decision making informally. Now we have the formal supported decision making, so having that contract or agreement in place and in writing. And then we move on into situations where perhaps those protections aren't appropriate, and then we still have to look at a limited guardianship where we carve out some of the rights or decision-making powers and still have to go through the court process, and ultimately still considering full guardianship and conservatorship if that's appropriate under the circumstances. So we'll break those down. So with that, I'm going to talk briefly about powers of attorney. Many of you probably know, hopefully you have your own. Powers of attorney in Arizona can be a number of different documents. Primarily, you're going to see a healthcare power of attorney. That is a document that says if I cannot make or communicate my own healthcare decisions. Here are a list of agents, which are individuals, often family members or friends, as well as in some cases professionals who can step in and make decisions on my behalf when I'm no longer able to. A healthcare power of attorney in Arizona is also going to include some decisions as it relates to organ donation, autopsy, things like that. A healthcare power of attorney can be used for any individual when they're under anesthesia. Sometimes they're used when an individual has dementia later in life. Sometimes they're used for young adults who have the capacity to understand what a power of attorney is, sign that, and that's appropriate. We also have in Arizona a mental health care power of attorney. A mental health care power of attorney is going to be specific to making decisions about mental health, usually specifically as it relates to the ability to admit to inpatient psychiatric care and treatment. So it's a very specific power of attorney common in Arizona. And then we also have a financial power of attorney, a durable general power of attorney, but a power of attorney that can be effective either immediately or it can be effective springing, meaning only upon incapacity, meaning a later time a doctor would make a decision that you're no longer able to act as it relates to financial or contractual decisions. Those powers of attorney can kind of vary in length and strength. And so in many cases, we want to have a broad and powerful financial power of attorney, because for many of us, when we have capacity to sign that, we want to make sure that at no point in the future does a guardianship or conservatorship need to be considered or used. So powers of attorney in and of themselves, and I guess I should mention quickly or briefly, there are also education powers of attorney and a few other very specific types if we have a very certain need, but those are the most common as healthcare, mental health care, and finance. So with the power of attorney, the laws in Arizona are that a healthcare power of attorney can be signed and it either needs to be witnessed or notarized. And a financial power of attorney or general power of attorney has to be both signed, witnessed, and notarized. I think I said signed or notarized. It needs to be signed and either witnessed or notarized. Where finances, it needs both a witness and a notary. And so a power of attorney really empowers us to put the right team in place. It allows us to pick who's appropriate. We get to consider, who do we trust? If we have siblings that are appropriate to make our decisions, one might be better at finances than healthcare. It allows us to put that in place, oftentimes for the future. Powers of attorney are inexpensive. Healthcare directives are available for free in Arizona through our Attorney General. They're pretty straightforward and kind of simple documents, but they work great for a lot of people, so they can be free. Otherwise, they're pretty inexpensive to either get online or to see an attorney and work with. They're easy to download, to print, to sign, all of that, quick to complete, and they're easy to change. So if one week I put my brothers in there as my decision makers, and then the next week they make me mad, I get to sign a new power of attorney. Not a big deal. And so those powers of attorney are good in a lot of ways and appropriate for everybody who's over 18, who at this point it's appropriate for. But the downside is a lot of the same as the upside. It can be easily revoked. And so for a young adult, if a parent or a caregiver is relying on that power of attorney to perhaps participate in medical decisions or go to IEP meetings or participate with DDD, the adult on a whim, if perhaps they are upset with their parent or are frustrated or disappointed by their caregiver or just not understanding, can revoke that. The other big downside is that the other big downside in some cases is that the presumption remains that the adult who signed the power of attorney has the capacity to make their own decisions. So in fact, it actually requires that that the person working with them, the doctor, the medical team, the school, relies on that individual to make the decisions when they can. And so it doesn't always allow for a parent, caregiver, or supporter to participate in conversations or to even get the phone call when it's necessary that a signature or a decision needs to be made. And that individual then also can still contract. So they can go down to the car dealership with their new boyfriend or girlfriend and co-sign that loan, or they might go to the courthouse and get married. So all of those powers to contract are still valid and presumed valid. So you can start to narrow down whether or not powers of attorney are appropriate. But that being said, for a lot of individuals, they're really good for anybody over 18. If we look then, or jump then to the other end of the spectrum, what we're looking at is a guardianship. And so with a guardianship, what we're thinking about is the guardianship is related to this power to contract and make decisions. And in some cases, we want to involve the court such that it takes away their right to make decisions. That's usually to put into place protection, but in a lot of cases, it's a really big deal. And so with guardianship, what we're doing is we're filing a petition with evidence, so usually relying on a medical report that says this individual does not have the ability to make decisions safely for their own. They've considered less restrictive alternatives, and we need the court to take away their legal right to make decisions and in fact give it to this individual or these co-guardians. And so that process, because it is such a big deprivation of rights or taking away rights, we have a lot of due process that we have to undergo to get there. And so with a guardianship, which you're probably familiar with, we have to file a bunch of documents with the court. The court sets a hearing, and in between the time we have the hearing and when the hearing gets set, a number of things need to happen. So the individual with a disability or limited capacity has to get their own attorney appointed by the court. They have to usually be personally served with the documents, meaning a copy of the petition asking for the appointment, as well as a copy of the notice of hearing. There is a court investigator who gets involved, and there's a hearing, and there's a whole bunch of different things that come up. Well, guardianship in and of itself can feel quite daunting for those who are petitioning and going through the court. And in fact, it changes a lot for that situation. And so what we experienced when this law passed this summer is, in fact, they introduced a bill that was kind of the extreme of this, and that was saying guardianship should be really easy, and in fact, we should take away a lot of those legal protections and allow for DDD to more quickly help families or parents get guardianship. And so that kind of reaction to that was some of what we're seeing in getting this in place. And so there are some benefits, and guardianship is absolutely appropriate in a number of cases. One of the benefits is that, of course, that prevents that individual from being taken advantage of, because once their presumption has changed that they cannot make decisions, then in the event they get taken down to the car dealership or to the courthouse for that marriage, that's not a contract that they've entered into. And so the presumption changes and those decisions are invalidated. Guardianship is well recognized by doctors, DDD, schools, and in fact, a lot of people, as you get near 18, are starting to ask for some of this paperwork. So you can actually start the guardianship process at 17 and a half, and a lot of times we want to have that in place when it's consistent and ready. General guardianship is taking away almost all rights as it relates to making about your decision, but it still requires that the guardian in fact make the least restrictive decisions and maximize the independence of the individual. And so with that, with a general guardianship, then we are typically taking away the right to drive and to vote and to get married, to make medical decisions, to make contractual financial decisions, all of the above. Once the guardianship's in place in Arizona or Maricopa County, it's actually pretty straightforward to get the annual reports filed. It does require an annual report of guardian as well as a statement from the doctor. And it tends to go on. And of course, the courts are supportive of coming back and adjusting the guardianship, perhaps turning it into a limited guardianship or the like. But it's a big deal. And so for a lot of folks, it feels very overly restricted and restrictive. And it is not, in fact, the least restrictive alternative. And so with that, another big downside that many feel is that the process can be expensive and stressful depending on how you go through it. And because it is such a strong legal maneuver, it sometimes does require hiring an attorney and can be expensive. So with that, now we're working our way back. Sometimes we want to consider a limited guardianship. Sometimes it's very clear that the person we're providing care for should not be making all of their decisions right now, that perhaps a diagnosis that they have is impacting their ability to protect themselves or their ability to rationally make decisions that are in their best interest. And so a limited guardianship, much like a general guardianship, does still require the court. It requires much of the same legal process and due process pieces in place. But what we want to do is more carefully constrict the guardianship to the powers that need to be made. And so in a lot of cases, there are individuals who perhaps because of vulnerability or otherwise, we do need to restrict their ability to make decisions regarding finances and contracting and perhaps marriage. But on the other hand, they can still make decisions regarding their social life. They can make decisions about marriage, perhaps. In some cases, we're preserving somebody's right to drive or to vote. With those different pieces, we'll need evidence. So what we want to do is be clear that when we're working with the doctor and with what we provide to the court, we've really outlined why perhaps this individual's diagnosis of X, Y, and Z does allow them to safely operate a motor vehicle, but does not allow them to safely go to the doctor's office, understand the pros and cons of the different medications, taking the medications, and making medical decisions. And so it is a bit more specific, which seems appropriate. And so a limited guardianship can be really helpful. So the pros of that are obviously it does more so empower the adult to make the decisions where they can. It is a less restrictive alternative, and we can protect the right to drive and vote with clear and convincing evidence. It grants the same authority. So you get the same paperwork, which many agencies are very familiar with. So when we look at letters of guardianship, they look very similar to letters of limited guardianship. And so DDD is expecting something that what you hand them. The doctor's familiar with it. They're really used to it. And because we have a limited guardianship in place, we do have a court case that's open, and in the event of an emergency and we needed to go back and reframe the guardianship, we're able to do that more easily. Of course, the downside is it still does require all those due process protections. However, of course, in the wrong cases or in the right cases, that's not a downside. We want that protection for the individual. And it does still have the same fees and costs of the general guardianship process, and there are still the annual reporting requirements. So you've kind of seen we're starting to surround supported decision making. On one hand, we've got these complete autonomy with hopefully powers of attorney in place. On the other hand, we've got the general guardianship and limited guardianship. And in between now, we have informal and formal supported decision making. So trying to figure out how that works or what that looks like. So informal supported decision making, right? Just going to dinner with your friends, calling mom and dad, asking for support is really empowering. It's nice as a caregiver, I'm sure, to get support from your friends and family when you have a tough decision to make. It's flexible. I can go to different groups of people for different types of decisions. I have a sense of how people feel in their own personal philosophies and whether or not that matches with mine. And it really increases my independence. In some ways, it's good also because it forces me to still make the decision. And so sometimes that practice of being required to do that is really helpful. And I know a lot of times as parents with teenagers, you're trying to encourage the practice of making decisions. And so it's very similar to that. The downsides in some cases are there are no legal protections. The adult is an adult. We have the same legal protections as complete autonomy with informal supported decision making. So if something goes wrong or something goes sideways, we have to deal with the consequences as we normally would. Informal supported decision making, really, doctors, EDD, they're not going to recognize that. They're not going to understand that this individual wants to bring, 10 of their friends to their DDD quarterly meeting. Well, that's probably just not going to fly. So a lot of information is deemed confidential or not available as a result of HIPAA or otherwise. Again, informal supported decision making does not prevent the individual from contracting. And so if something goes sideways, we have to deal with consequences of that. And with informal supported decision making, the adult, of course, can quickly change their supporters or end that informal agreement, meaning if I don't like what you're suggesting I might do, I'm going to move on to a group that does support what I want to do. So again, different for everybody. And so now we have formal supported decision making. And as I mentioned, this is just a tool in our toolbox to help us make these decisions, but you can see where we're getting is that there's a lot of pros and still some cons, and it's not going to be right for everybody, but it's kind of an awesome tool that says, okay, let's do our best. Let's take this individual who needs to make their own decisions and who can make their decisions, but let's give them, like we talked about in the beginning, some access to records, some access to helping communicate. Let's empower the individual to make their own decisions. It is still very flexible. It provides a lot of autonomy, increased independence. I apparently forgot to change this slide, but soon to be legally enforceable. It is legally enforceable as of a couple weeks ago. So that means that legally enforceable, we have those consequences. If somebody violates that term of that supported decision making, we have a tool to punish them. And so penalties and punishment for abuse of the power are really important as well, because we do get that with powers of attorney. The cons are it's still very new. Of course, there's also the downside that the wrong supporters might take advantage of this as a way to get information or negatively influence the adult. It still doesn't prevent the individual from contracting because they're still making their own decisions, and an adult can quickly change supporters or end the agreement. And so if we start to look at a formal supported decision making, what that means to me is that when I meet with families and we're talking and we've got a young adult who is making a lot of their own decisions, but perhaps has limited communication, a supported decision making agreement is a great way to support that. I'm often, almost always, can't really think of a reason why I wouldn't, going to recommend that if an individual is going to sign a formal supported decision-making agreement, that they also sign powers of attorney. Because like I said, for every adult, we should have those powers of attorney in place. And they kind of go hand in hand, because even with the formal supported decision making, what we see is that we need to have coverage for in the event that adult in the future loses their ability to make or communicate their own decisions. So same piece there. We want to have a lot of times those power of attorney documents in conjunction with the supported decision-making agreement in place. So the question is, does it work? As you're seeing, it's still obviously very new here in Arizona. In fact, nationally and internationally, they are doing quite a bit of research on its effectiveness, but we don't have any clear results at this point. You hear a lot that they're really good at implementing this, and it's quite a useful tool in places like Canada and some of the earlier places that implemented it. I'll also share with you that many of the states that have passed these laws, the legal practitioners are really not seeing much utility. They don't have many cases where that is the right fit, that people that are coming to see them because they're concerned about somebody turning 18 or a young adult having a limited capacity to make decisions, they're usually still falling into a guardianship or a limited guardianship. There are one or two states who court systems are actually pushing families to start with supported decision making and then requiring evidence that the supported decision making fails before they go through guardianship. I don't always know that that's the right case when we have a lot of things at risk there. So, I don't know that that's going to be the right solution either, but I do think, and have in fact have had a client or two in the last 3 to 4 months where this has been a really good solution. And so I think there's a lot of opportunity here. I just don't want to see it implemented in a vacuum, meaning we have perhaps a formal supported decision agreement in place, but we don't also have powers of attorney or other checks and balances as well. So a lot of good stuff there. So with that, I feel like I've just been talking a lot. I don't know if that matches what your thoughts were. The other thing I can do is perhaps you guys have a question or two, but I can stop sharing my screen here. And I'm going to pull up the statute itself so we can walk through that a little bit. Does anybody have any questions while I'm doing that? Come on, somebody, anybody? I know I didn't do that good a job. Michelle, is this what you thought it would look like?
Yeah, no, I think this is great because I think that's always the question is like, where does this fit in with the broader array of options that we have for our loved ones? So I think you did a great job kind of separating it out and teasing where it belongs in that space.
Okay.
So that's great. And I did have a quick question, Emily. So when let's say you do have a formal supported decision-making document, is that filed with the state? Is that something like you can actually see how many of these are being used, or there's like no formality to filing these things?
Right. And so that is, one of the pieces is it's going to take a while. It's really going to take a while for banks and federally mandated protection places to accept them and allow them to be used. I think it's even going to be a little tricky with DDD and schools and doctors. I mean, that is the hard part there. You don't get the stamp, you don't get the letters, you don't get the court proof. And I think that's really one of the big downsides. And I think that's why it has to be in conjunction with those powers of attorney or those, HIPAA waivers and that kind of thing. So, it's tricky in that way. I did see, there are some kind of rough estimates of, like the UN has some kind of numbers. I just don't know how real those numbers are because there is no reporting requirement. So
I always think it's fascinating that we pass these things and we don't require any kind of reporting or documentation or any way to like know if it's being used and implemented the way that we thought it should be, right?
Yeah, and I think that's the hard part is I think a lot of attorneys probably come from kind of a jaded space. And so, the first reaction in most of our circles is, oh man, this is going to get abused. This is going to be so bad. And that I'm trying to be really open to it. But that's why I also want to make sure that it's really the right situation for everybody. And that's why I know it was kind of silly the way I started the presentation with us making our own decisions, but there's so many ways that I can be negatively influenced in making a decision. And I'm, in my 40s and been making decisions for a long time. And so it's hard. And I think that it's really I know a lot of families struggle with moving forward with guardianship because you spend your whole life developing independence and winning all these milestones, and then to have to go back to court and it feels like you're kind of rewinding. But there is a lot of instances where I think limited guardianship and guardianship will be appropriate during young adulthood while somebody gains more experience in making decisions and figuring out ways of communicating and advocating for themselves. So yeah, good and bad.
Yeah, and I like that with the supportive decision making that they can help with communication, because I have a nonverbal son, and as we teach him spelling, spelling is an assisted form of speech. So a lot of formalized places don't accept spelling because somebody's facilitating communication, but I like that with supportive decision making, that is part of it, right? So I really appreciate that.
Yeah, absolutely. I think some people are concerned about frustrations and timing, right? So the other piece is you're a busy professional mom and you've been doing this for 18 years or however long you've been doing it. It's like, shoot, I can't just go have the ease of making that decision. So it actually puts a lot back on your plate to be a supporter, because you can't just skip that step when it's time. So a lot of that. I think there is one question, or was that just your chat? Will be explaining step by step. Yeah, so let me show you that right now.
The perfect segue, Karen. Thank you.
I just got to get the piece together. So step number 1 is making sure it's the right piece. Step number 2 is, let me share my screen. Okay, so I'm going to show you the law, because the law actually gives us a really good example of a document. So this is a form that is or can be appropriate. So all of our guardianship, estate, and protective proceedings fall under Title 14. And so if we go there,
this is apledge.gov.
Yep, and I can share the link with you. Awesome. And I can share you a Word document version of the form they put in place. I just want to show you how this all kind of fits in the law as well, because I think it gives you some good perspective of how we're considering it as lawyers. So I'm going to skip over probate because we're not talking about probate in this case, but we're talking about Chapter 5, protection of persons under disability and their property. So whatever the language is, that's what we currently have. And this Chapter 5 is what describes guardians of minors, so individuals whose parents for some reason cannot make decisions. And then it goes into guardianship of incapacitated persons. And so this is all the process, not all, there's more rules, but this is a lot of the very specific statutes as it relates to guardianship and how you get a guardian appointed and all of that. You can see there's one tiny little limited guardianship statute that also goes into voting. However, voting is also in our state constitution. We've got protection of property of persons under disability and minors. This is property, so this is conservatorship. So there's a few more rules there. We've got powers of attorney, so a few little pieces there. Public fiduciaries, and then right here, brand new, Article 9, supported decision-making agreements. And so there's just 2 statutes that control this. And so the first one, oh, did you have a question?
I'm surprised. I love that it's like its own little deal there. I was surprised it wasn't tucked into anything else. So that's interesting.
Yeah, so definitions, just going to define what this means. So adult disability means a physical or mental impairment that substantially limits one or major life activities. Interested person, intimidate supported decision making, and they formally define it as making means of a process of supporting and accommodating an adult to enable the adult to make life decisions, including decisions about where the adult wants to live, the services, support, and medical care the adult wants to receive, whom the adult wants to live with, and where the adult wants to work without impeding the adult's self-determination. I actually think that is kind of a narrow description when we think about all the types of decisions we have to make, but it is what it is. And then supported decision-making agreement, and then supporter. So one of the 2 statutes is just definitions, and then the other one is everything else. And so really it's this link that you would want to take a look at. And so it's defining for us what the scope is. And so this goes through a lot of the different pieces we talked about and who can be a supporter, what they can do and what they cannot do. But then right here, this says the supported decision-making agreement shall be in substantially the following form, which is odd because we don't get that for everything else. We don't get this for powers of attorney or trusts or wills, things like that. There are, of course, legal requirements, but this is our way of, or the court's way of offering a version for you to type it up in your Word document, handwrite it, that kind of thing. And so giving us really here. So it allows or spells out the things that should be included. And so the reason why this is important is when you're putting one of these together and you're hoping that it's going to be, excuse me, my mouse is kind of wild, recognized by a bank, you know, a doctor, you're going to want this so to reference. And so it really just outlines all of that. I think, or I anticipate that over the coming years and decades, this will be further defined and corrected and either broadened or made more flexible. So it's more individualized. But if I, you know, scroll down, it's really just talking, it's literally a form. And so I, Emily Taylor, as decision maker of sound mind and enter into this agreement voluntarily. My disabilities are described briefly. I choose Michelle to be my supporter. Here's my supporter's contact information. Here's a checklist of the things that Michelle can do for me. She may help me with life decisions about each of the following, which I have marked with an X. Choose which of those might work. And then ultimately get it signed. Consent of the supporter is suggested, perhaps required, to be determined. So that means Michelle would need to sign off on this as well. And then it does require a witness, or excuse me, two witnesses or a notary public. So it needs to be signed. And of course, I would presume, it's not, I don't think it's very clear, but it should be an independent witness. So Michelle can't be the witness to me and I can't be the witness to her, vice versa. And so it's really straightforward. And so the answer is, Karen, you type yourself up one of these and get it signed and start to use it. And so again, you know, when we start to think about those pros and cons of what we were looking at with powers of attorney, it's a lot of the same things. This is really easy. If the person you're caring for or your supporter for gets upset, they can go find their own version and cross somebody's name off, that kind of thing. But it's also great because you can go do it today. It's not going to take a lot. So a lot of good things there. But does that kind of help, Karen, answer your question about how to put that in place? Okay. And then I would say, of course, because they're of sound mind, they should also be signing all the powers of attorney. And I'll send Michelle that link as well, so you can share that, Michelle, the Attorney General's forms for those. There is not a great financial power of attorney available for free in Arizona. The one that the court does offer is very limited. So I usually encourage you to talk to an attorney to get some broader documents in place for that. But so it'll be interesting to see.
Yeah, I mean, I think you're right? I remember you and I having conversations as this was going through, and you're like, "Ooh, what this is going to mean for us, like really how this fleshes out when it comes to the law." But I think, you know, it is fascinating because it's almost like having power of attorney, but I do like that there are repercussions now if people are not doing what they're supposed to do in a formal supported decision-making agreement.
Right. And I will say this has been going on informally for a long time. So, you know, as we kind of talked about, that's the case. I also have many families who come in and say, hey, we're in our 70s and our adult child is in their 40s or 50s and we've been getting along fine. But now we should probably put guardianship in place in case we die. So I think the hard part is that we're also working with agencies and legal entities that are causing so much more too, because, you know, I go to a bank, I can barely get my own signature recognized. So it'll be interesting to see how that all plays out as well. But yeah, there's not a wrong answer. And for many families, it'll be very clear, but there's also a good group of people who we're going to try this and see if it works. And it'll be a good solution so long as it goes hand in hand with some other pieces in place.
Yeah, and I think I like, I like the idea of starting with as limited of guardianship as you can. I know some families now who have gotten guardianship for their children and are trying to reverse it as they're getting older and more capable and are having a really hard, Karen's like, yes, that is me. Having a really hard time getting these guardianships reversed because you've deemed them incapacitated, right? And so it's been hard for a lot of families for the courts to understand how that could have changed. And can
That's
you talk
it's interesting
about
because yeah, for sure. So, um, for better or worse, I probably do 7 or 8 guardianships a month. So I'm in front of a number of different commissioners, and we do see trends and changes based on who's on the bench and all of that.
that?
Um, but I feel like, especially in the last, I'll just say 5 or 6 years, I've been practicing for about 16 years, and maybe I just don't remember it as clearly, but really in the last 5 years, a number of the commissioners, especially here in Maricopa County, are very supportive, and in fact, end most of our hearings saying, please come back when you're ready to terminate this. Have a doctor sign off on it, and please come back, and I have had a number of times where we've gone back specifically to support retaining or reinstating driving. The only thing I'll say contrary to that is voting. For some reason, that's gotten trickier. That piece has gotten really, really tricky because some of the commissioners historically or judges were very supportive of it. The Constitution in Arizona is specific about voting, and you need clear and convincing evidence. And I think there's probably been a little bit of political, I don't know if it's real political pressure, but political pressure to really make sure an individual is making independent decisions. Because it is hard to say, hey, they can't make an independent decision as it relates to medical issues, but they can about political, things like that. So that's the piece that I've seen a little bit, but most of the time I'm in a guardianship hearing, the commissioner is saying, please come back when you're ready to terminate this. We think the parents are in a good position, you're doing the right thing. So I don't know, it's changing. And then the other piece is, like I alluded to, some other states where they're going to the extreme opposite, and they're saying, we're not doing a guardianship until you prove that you absolutely need it. You've tried everything else. And so it's
Oh,
probably just one
yeah,
of those things
that's
that are,
fascinating too, because it's like, man, what if they make a really bad
well,
decision during that time?
yeah, there was this attorney who was like, the client or the individual they were going pursuing guardianship for was like literally in a coma or something. I don't remember exact details of it, but it made no sense. And this was a East Coast state that was pursuing it. So it'll be interesting to see. And these, of course, are all rumors. So, but that being said, I think if you've got a supportive medical treatment team that's willing to put into place a report that says, yeah, in fact, they are demonstrating the ability to do this, then I would think that the court will be supportive of it. But I can't guarantee that, of course, because I don't know the judge and I don't know exactly what the circumstances are. But
Okay.
yeah, yeah,
Awesome.
yeah.
Does anyone have any other questions, Karen or Amy? Any other questions for Emily?
No pressure. I know it's,
Oh, awesome.
yeah.
I had written down a bunch of questions, but you answered them as we went. And you did say there is research going on right now, but not a lot published on whether or not supportive decision making makes a difference.
Yeah, so when I started really looking into this issue earlier this year, when it was becoming a really hot topic, and then ultimately the law was signed, I did some research on it. Essentially, the UN is one of the big pushers of, pushers is probably the wrong word, but you know what I mean, of this type of thing. Like I said, Canada tends to have a really good way of doing it, and I think some of it is cultural too. But there has not been a lot in the United States, just because the number of states who have passed it and then the number of people who have actually used it formally in a way that's trackable or researchable is very, very small.
How fascinating.
Yeah.
Okay. That's just,
Yeah.
such a nerd. I'm just like flummoxed.
I'll look again and I'll see. I'll try to keep.
Like, but it is fascinating. All right. Well, thank you. Thank you, Emily. And anybody who watches this video, if you guys have questions or need help, you'll see Emily's contact information below on the page that we're going to post this. or in the email that we're going to send out. Emily is fantastic, not just for guardianship, but if you guys need help with special needs trust, I know my husband and I are going in next week, I think. And so
Not next week. I'm not going to be
not
here next
Christmas.
week.
All right, maybe a couple weeks. But to finalize our stuff with you, and just thank you so much for showing up here today and for walking us through that so cleanly and trying to separate all of these different options that parents have for guardianship, because it is overwhelming and it can be very difficult to make these decisions. And it's nice to know that there are a lot of different kinds of decisions we can make for our loved ones. So thank you for walking us
Absolutely.
through that.
Absolutely. And I think the really important thing too is to not get too deep into it, just to really go back to the basics of decision making and how do we do that and how does every adult do that, because it is so important, and important in your case. So thank you for the kind words and letting me present today. And I'm always happy to support you guys. So thank you.
Awesome. Thank you, Emily. Have a great day.